The Florida Bar versus Horton. Please proceed.
May it please the court. Good morning, or actually good afternoon, possibly, Chief Justice and Honorable Justices. My name is Carrie Lee, and I'm here on behalf of the Florida Bar. We have asked for review for the reporter referee for two reasons. The first is the referee's finding of the mitigating factor of remorse, which we believe clearly is not supported by the record. Additionally, and more significantly, we believe we have sought review as to the referee's recommendation of a 24-month suspension, non-pro-tunc, to this court's order of May 2017. We believe, based upon this court's lengthy case law, as well as respondents' egregious and cumulative misconduct, as well as the standards for imposing lawyer discipline, warrant disbarment in this matter. We believe disbarment is appropriate for these reasons based upon the referee's findings. First, that respondent engaged in a pattern of activity that were focused on his own best interest, that of solving his financial crisis, or as he quoted it, liquidity crisis. Additionally, the referee found that respondent took advantage of vulnerable clients. Three that are mentioned in our brief were Mr. O'Connell, who was 85, Ms. Berry, who I believe was 75, and as well as Mr. Lohman, who was 74. He was familiar with each of their financial situation and assets, the referee found, and the referee also stated that he, while knowing these financial circumstances, had unfettered access to take loans from them to alleviate his own financial issues. Additionally, the referee found had he not been able to come into additional income, he was putting them at significant risk had he not been able to reimburse them. And at the time he was taking these loans, he did not have the funds to reimburse them. More specifically, the first matter is Mr. O'Connell. As I previously indicated, Mr. O'Connell was 85 years old. He was living in an assisted living facility, and he had disinherited his family, so he had no one looking out for him. In 2014, Mr. O'Connell hired respondent to assist with his financial planning. And at that time, the respondent would issue regular invoices to Mr. O'Connell in the year 2014. However, in the following 2 years, in 2015 and 2016, those invoices stopped. And as such, Mr. Horton, the respondent, made 34 checks to himself in the amount of $43,000, around $43,000, and returned almost $5,000 of that. Additionally, in 2016, he issued 33 checks to himself in the amount of $82,000 and returned half of that. And the referee found that there was no rational basis for fees over $40,000, especially given there were no invoices in Mr. Horton's own testimony. And then in 2017, he took no fees at that point. When the bar began the investigation, respondent then proceeded to send a letter to Mr. O'Connell advising him of those fees that he took. However, he failed to mention these transfers back and forth from Mr. O'Connell's account and back to respondent and then back. So he only mentioned the net amounts that he was taking, and some of those net amounts weren't even accurate. And then he reported to Mr. O'Connell, because I took the fees in the 2 previous years, I'm not going to invoice you or charge you for any of those fees. Mr. O'Connell wasn't aware of what was going on as respondent had changed pursuant to Mr. O'Connell's request the addresses and names on the account, so all the statements were not going to Mr. O'Connell, they were only going to respondent. Again, the referee found that in that letter, it was a violation of 4-8.4C because he failed to truly represent what he was doing in his accounts. We also have Mr. Lohman. Mr. Lohman hired respondent in 2005 to draft his testamentary documents. In that first initial document, respondent named himself as beneficiary in that trust, and then that document was subsequently amended 5 times. And the last one was in 2011, where respondent wrote himself into the will in order to receive a 50% distribution. This was all with Mr. Lohman's permission. However, Mr. Lohman was another client who had no family or friends, who sought respondent friendship, and ultimately that made the relationship even more precarious, and that respondent did take advantage of him. And in 2016, Mr. Lohman found himself to be hospitalized and needed assistance with paying his bills. At that time, he contacted respondent to help him, and pursuant to a power of attorney, respondent did pay some of those bills, and while knowing all of his financial assets, proceeded to ask for loans. He took 3 loans from Mr. Lohman totaling $90,000. In each of those loans, he failed to follow the rule regulating the Florida Bar of 4-1.8 that required them to reduce the terms in writing, to have him seek independent legal counsel, as this court has said in many cases that the point is to protect the client as well as to keep the business transaction at arm's length. And in each of those loans, he failed to comply with the rule. Additionally, he also wrote himself a check in the amount of $1,000. Mr. Lohman was not aware of that amount and had not agreed to that amount, and as such proceeded to close the account.
That was the $15,000 check?
There was an $1,000 that he wrote as fees to himself. And then at that point, later, respondent did write a $15,000 check. However, that amount did not clear because Mr. Lohman had at that point closed the account. He later, after the bar investigation began, respondent did finally send a promissory note to Mr. Lohman indicating that he would reimburse him with interest, and that was sent in November of 2016. And ultimately, he did repay Mr. Lohman in January of 2017. The last client was Ms. Berry. Ms. Berry hired respondent to assist with her testamentary documents, and unfortunately, she passed away on September 5th of 2015. The next day, respondent wrote a check in the amount of $17,500 to himself, half for attorney's fees and half as a personal representative. The referee found that that was fraudulent as he had not yet been appointed by the probate court as personal representative. He had filed the documents, however, the court did not enter the order until 2 days after he wrote that check to himself, and the court found that he had no authority to do so. Again, in this instance, he also wrote a check in the amount of $15,500, and that was the same day that the check from Mr. Lohman that he attempted to write to himself did not clear. And when asked during his sworn statement, respondent said, no, it was not a coincidence. He needed money. Additionally, the bar conducted an audit of respondent's trust account, operating account, and personal accounts. The referee found that the respondent misused client funds, and as the court knows, the misuse of client funds, disbarment is the most appropriate sanction. He failed to follow the minimum trust accounting procedures, as well as he commingled client funds by placing credit card client cost deposits in his operating and did not transfer them to the trust accounts. Therefore, he was commingling of funds and the record clearly reflects the numerous overdraft fees that were occurring in that operating account, resulting in those client funds to be used for another purpose. For instance, in 2015, he had $5,565 in just overdraft fees. And in 2016, he had $6,265 in overdraft fees. So in over a short period of a couple years, he had almost $12,000 just in those NSF overdraft fees that were occurring in his operating account. Additionally, we have sought review in regards to remorse as to the mitigating factor of remorse found by the referee. The record clearly shows that respondent exhibited no remorse, and we believe that this court should find that there was no remorse. More specifically, in his testimony at the final hearing, he said today was like trying to kill an ant with a sledgehammer. He also said the bar was prosecuting him as a trophy being hunted for the kill, so his head could be mounted on their wall as a trophy killing. Additionally, he also said it was like facing a firing squad for a traffic violation. The referee found the following aggravated factors: that he was selfish and dishonest, that there were multiple offenses, a pattern of misconduct, and vulnerable victims. We believe that disbarment is the only appropriate sanction given this court's case law as well as the egregious conduct by a respondent. Thank you. I'll save the remainder for my rebuttal.
Thank you.
Good afternoon. I'm Brett Gear. I represent Dennis Horton. We cross-appealed this case based on the procedural irregularities that occurred throughout the case. The Florida Bar instituted a 6-month-long and extensive investigation of Mr. Horton based on Mr. Lohman's complaint that was actually handwritten by the bar investigator. We don't know the backstory to that because Mr. Lohman never testified. As counsel has told you, there are basically 3 clients that were the focus of the bar's investigation. The Florida Bar subpoenaed 10 of Mr. Horton's client files. He completely complied. His cooperative attitude toward the proceeding at all times. 3 trust accounts, 2 operating accounts, his personal bank accounts, all of that was provided, boxes and boxes of materials. This all happened before I got on the case. They decided to depose Mr. Horton twice. He exhibited a cooperative attitude toward the proceeding. He was extremely candid. He admitted violations of the rules. He admitted his financial distress. He admitted the how and what of what occurred. Absent in the bar's presentation to the court today is the fact that they called Mr. Lohman in to testify on deposition after taking Mr. Horton's first deposition. Mr. Horton was represented by counsel. Mr. Horton and counsel were not advised and did not know about the deposition of Mr. Lohman. As stated, the 3 clients that became an issue through this extensive investigation into Mr. Horton's conduct, 2 of them were alive, apparently able to testify. The bar did not call either of those 2 people. They relied on the one-sided deposition of Mr. Lohman that was taken after he received his proceeds from his loans. And the second, and apparently did not deign to call Mr. O'Connell at all. Mr. O'Connell and Mr. Horton had a very friendly, congenial relationship as client and lawyer. I don't recall any evidence that was put forward that Mr. O'Connell had disinherited his family. I could be wrong about that. It might be in one of the exhibits, but that was really not a feature of the trial. The reason that we decided to cross-appeal really, though, was the nature of how this case proceeded from the start. After 2 depositions and a closed deposition of the complaining witness, at which Mr. Horton and his counsel had no opportunity to cross-examine Mr. Lohman, the bar decided to invoke Rule 3-5.2 and file for an emergency suspension of Mr. Horton's law license. That was granted. The reason that we have filed this cross-appeal is that under Rule 3-5.2, there really is no mechanism for the responding attorney to challenge whether or not there is a clear and present danger to the public, whether or not there is.
You know, that ship has sailed. We're here now. I think we know what happened, what these financial improprieties were, and your client has admitted that he broke the rules, correct?
He admitted that he broke some rules. He admitted that he...
Isn't it apparent from this record that he was treating client funds like it was his personal bank?
No.
And he was okay, explain why that's not shown by the record.
We'll take Mr. Lohman. Mr. Lohman, they were friends. The record is replete with evidence of their friendship. They were friends. Mr. Horton did admit that he was in financial distress. Mr. Lohman is the one, as Ms. Lee mentioned, that contacted Mr. Horton to come and help him because he had been hospitalized and he was recovering and he could not pay his bills. He knew that Mr. Horton had a power of attorney, which had never been exercised. It was just in the file. So Mr. Horton went to, I think it was Ormond Beach or Daytona, and visited him in the course of this meeting. You know, how you doing? He's in financial trouble. He goes, let me loan you some money. He offered it. He admits that. Even in the one-sided deposition, he admits that he wanted Mr. Horton to be a beneficiary of his trust. And he admitted that he wanted to loan Mr. Horton money. Mr. Horton testified that he offered to give him a note, and he was offended by it. He said, no, that's not necessary. And it was really kind of a sequence of transactions where he took a loan of $50,000, another loan of $20,000, another loan of $20,000, totaling
What about the
$90,000.
$15,000 loan that Mr. Lohman denies that he authorized? Tell me about that.
Yes, sir. If you read the referee report, it was unclear to the referee and really in the evidence as to whether or not there was a basic disconnect between the two understanding between Mr. Horton and Mr. Lohman about the amount or number of loans that Mr. Lohman was agreeing to provide. He apparently got upset when, and Mr. Horton did go off and do all these things for him under his power of attorney while he was in the hospital, and that's why he took the $1,000 fee. Apparently that upset Mr. Lohman, and he contacted the Florida bar. What the report says and what the referee could not determine was whether or not the two parties had agreed to that additional $15,000, and that's where the thing fell apart.
Let's move on to talk about Krista Berry, the funds involving Krista Berry.
Krista Berry disinherited her 2 children. She went and had a will made by Mr. Horton. She later amended the will. She again disinherited her children. Towards the end of her life, Mr. Horton heard from people close to Miss Berry that A, she was dying, and B, that the funny things were happening at the house. Her children were accessing the house and apparently removing items. He decided that this was an exigency, an emergency, applied for letters immediately, thinking with his experience in the probate court that he could get those letters of administration entered that day. He was wrong about that. He took the fee, which he was named as a PR in the will as all, and also was the attorney of record. The check that
He
he
had not
wrote.
been appointed, and he said, didn't he testify, I needed that money, so I thought I would take a portion of my personal representative's fee, even though he had not been appointed,
Yes.
correct?
Yes. Well, he took it before he realized that the letters weren't going to come through that day.
He took it immediately after he realized that Mr. Lohman had closed the account because of the $1,000 that was taken, and that he couldn't get that $15,000 that he attempted to get from Mr. Lohman. That's immediate. And then he took the $15,000 before he got appointed,
Yes, Your Honor,
correct?
that's true.
Okay.
And he admitted that. He said that was not a coincidence, that I needed that money.
Let's go on to remorse. Now, the trial court, the referee found that there was remorse was established here. Could you tell me where in the record there is evidence to support that your client is remorseful?
Not offhand, Your Honor, no. I mean,
Well, since that's an issue on appeal, I would think if it's there, does that mean that it's not there in the record?
no, I think the trial judge, the referee, could see the effect that this had on Mr. Horton and his
Well, I'm talking about
words.
some evidence that would support a finding of remorse. What I see in the record from the statements made by your client is an astounding lack of remorse and an effort to blame the bar for pursuing him for these matters where it seems to be established that he violated the rules of conduct that were applicable to him. So basically you're saying you can't identify any place in the record that shows remorse.
No, Your Honor. But I can tell you that he exhibited remorse throughout the proceeding. He did, I think, let his emotions kind of run away from him at one point and express his angst, as counsel has highlighted for the court. But throughout the proceedings, it is quite obvious in this record that Mr. Horton was very compliant with the bar. He was very cooperative with the bar. He was very candid with the bar. There's no evidence that he tried to hide any of this or that he tried to prevaricate or talk his way out of it. He had a liquidity crisis in his business, and he cut some corners. There's a rule that he didn't know about, which was not an excuse. It is an explanation. I think it goes to his state of mind. That's Rule 4-1.8, both A and C. That relates to the loans that Mr. Lohman agreed to provide, even though Mr. Horton said, hey, I'll give you a promissory note. He eschewed that, and Mr. Horton did not press the matter until he was basically advised of that. The same issue, 4-1.8, which was, this rule was promulgated in 1989, some 13 or 14 years into Mr. Horton's practice of law, regarding the testamentary instrument. It's not that Mr. Horton inserted himself into as a beneficiary of the trust. Mr. Lohman wanted him. It started out as 2%. He wrote it up the way Mr. Lohman wanted. If you read Mr. Lohman's one-sided deposition where cross-examination did not take place, you will see that Mr. Lohman was changing his beneficiaries all the time. And at one point he said, I want you to have 50% of it. He wrote it up, he sent it to him in Georgia with a letter saying, you need to have, counsel look at this. That doesn't appear in that's Respondent's Exhibit 23. That doesn't appear anywhere in the report of referee. It was notarized by a Georgia notary and sent back to Mr. Horton in Florida. Presumably, Mr. Lohman took advantage of that, or the problem with this case, Justice Kennedy, is that we don't know. Mr. Lohman was asked certain questions in a deposition, and then that deposition was entered into evidence as his testimony.
Did he appear at the hearing?
No. The bar did not subpoena either witness.
Did your client ask him to appear?
No, he said that he didn't want to bother Mr. Lohman, and
He had the opportunity to have him there?
it was represented to me by counsel that Mr. Lohman was not in any kind of medical shape to appear at the hearing, and I took their word for it, frankly. Also, it's the bar's burden of proof to prove the elements of each and every rule.
Well, you were complaining about the lack of opportunity to examine him. You had the opportunity to have him there at the hearing itself.
Mr. Horton did not want him subpoenaed.
Would you have been precluded from having a deposition?
It was our understanding that Mr. Lohman would not cooperate further with the bar or with us, and Mr.
You took the bar's, that's your representation of what the bar told you. You made no independent effort to pursue that.
Yes, I did. Mr. Lohman indicated that he would not participate further in the case, and he was sorry that he had, made such a fuss about the loan. Mr. O'Connell, his affidavit was entered into evidence, not considered by the referee. I don't know why. Mr. O'Connell.
Counsel, your time has now expired.
Thank you.
Just briefly, Your Honor. Just to clarify as to what Mr. Gear indicated, Mr. Lohman was not able to travel. How he could have appeared by phone, we did not feel that it was necessary, as that we did have his statement that we made. We did not notify Mr. Horton's counsel at the time because we were still at the investigative phase, and we're not required to comply with the rules of civil procedure.
Did the witness have a lawyer you failed to notify?
Yes, the witness did have a lawyer.
Did the witness have a lawyer that you failed to notify before you took a statement?
No, he was present actually when the statement was made. So we actually coordinated through Mr. Lohman's attorney, because at that point he had dismissed Mr. Horton and hired new counsel to assist with him. So not only did Mr. Gear not advantage at the final hearing, he could have done his own investigation and during the discovery phase and taken his, deposition. So while he's complaining that he didn't get an opportunity, he had plenty of opportunities to, one, take his deposition through discovery, and two, have him appear by phone. He was having medical issues, and so, as I previously stated, he couldn't travel. Additionally, for the court, all of his repayments and the loan documents were not written until after the bar investigation began. So who knows if this conduct would have continued but for the bar investigation as well as the emergency suspension entered by the court. Just for the court's information, we believe that disbarment is truly appropriate in this matter. We had 3 vulnerable clients who had no family or friends to look out for them, And knowing that the respondent took advantage of all three of them to assist with his own financial crisis. And I refer you to the record and the exhibits that clearly show that he was owing money to the IRS, he was owing money for business mortgages, and as such, he needed these funds. And he represented to the bar that he was doing so, taking these monies to assist with him with those. And as such, we think disbarment is the appropriate sanction. Thank you.
All right, we thank you. Well, you consume your time, but I will give you, if you wish, I'll give you 2 minutes.
Just briefly, Mr. Horton it's a shop-worn phrase, but Mr. Horton truly is a pillar of his community. I urge the court to read the transcript of the sanctions hearing, wherein I think 12 or 13 witnesses testified, and as to all of his civic involvement and community service. This is a gentleman who is adopted, he and his wife have adopted 3 children and he has devoted countless hours to his community in Claremont. It's an unfortunate situation that he found himself in, and there's no finding in the record that he didn't earn the fees that he took. Regarding Richard O'Connell, I think it's important for the court to read Mr. O'Connell's testimony in his affidavit, especially the letters that he wrote of his own volition to Mr. Horton once he learned that this proceeding had been initiated against him. Mr. O'Connell has no complaint with any of the services or any of the fees that Mr. Horton took or earned as a result of conducting all of Mr. O'Connell's affairs. There's no finding by the referee that any of these clients were, quote, vulnerable, other than just the bare naked finding in listing the mitigation factors, vulnerability of victim. Mr. Lohman was certainly not vulnerable. He was simply having a medical procedure and was in rehab. Mr. O'Connell you can read his statement. Miss Barry she had her own mind. These folks went to Mr. Horton for legal advice. She wanted to disinherit her children. He understood.
Can I ask you, I'm sorry to interrupt you. Can you just kind of, it seems like sort of, if I just had to kind of myself characterize what you're saying, it's almost like you're asking us to kind of view this as essentially not a big deal, and that your client has had a good career and he's been a good person in general, and that therefore we should just kind of I just want to give you an opportunity to kind of, in your own words, kind of summarize how you want us to view the facts of the case here.
Yes, sir. Thank you. I do not intend or mean to minimize the rule violations that were found in this case. They went through 10 client files and every bank record that Mr. Horton had. He produced those willingly. They found in 3 of these client files these activities. In the case of Richard O'Connell, this is a good point. Mr. O'Connell had, and it's in the record, Mr. O'Connell had a very thin margin between what his income, his investment income was, and what his monthly outgo was. And yet he had to pay Mr. Horton, and he had to pay hospital bills. He had to pay, if you read the letters that he wrote, he wanted to give gifts to the staff at the ALF, and he was a generous person. I guess he had a lot of money. I don't even know how much. But it looks and reads like much worse than Mr. Horton said it actually was. Because the margin was so thin, whenever a hospital bill came in or whatever he wanted to give a gift to his caregiver or a Christmas present or whatever, Mr. Horton had to go to his brokerage account, put more money into his checking account, pay himself, pay these people, and when he paid himself, he would find, oh, I owe a hospital bill or whatever, and he would put his fees back into the account. This occurred in 2014 to a small degree. It occurred in 2015 and to a larger degree in 2016. So what you have is a net fee taken that is completely consistent through prorated 2014, 2015, and 2016. He's basically taking the same amount of fees every year. But what we have, what we see in the record, and what was made to look so bad, and I don't think it is, that he was paying himself a fee, and then finding out I've got to put some of this back. In some cases, put all of it back, and then take it out later. So even though he took out $82,000 in fees, he ended up at the end of the year only netting 40, which was consistent with the previous years in terms of a month-by-month accounting.
Well,
You
I
can
just
see
have
how
trouble understanding about why he took the 82, because you can't take it if it's not yours. And you're saying basically it's fine because he ended up, the reasonable fee was what he kept, not what he took out to begin with. And so that's where I lose the thread of this narrative. Unfortunately, we're out of time. We thank you for
Thank you, Your Honor.
Thank you.
All rise.